Now, today we'll be discussing the concerns about the trial of civilians in military courts. Well, a debate has been raging on within the legal and political circles about the decision to try sometimes, civilians in the military court-martial. One of the cases that has seen significant importance is the case of the NUP supporters who were tried in the court. But also today we saw another development where former presidential candidate and leader of the FDC in the recent past, Dr. Kizza Besigye, was arraigned before the military court-martial in Makindye. So we want to understand the grounds under which such occurrence takes place, but also the issues that the politicians and those in the legal fraternity are putting across to try and question the ongoing trials. I have a guest list of three gentlemen. Let me introduce Advocate Samuel Ronald Wanda. He's a managing partner at Masiko, Wanda, and Arinda Advocates. Good evening, sir. Thank you very much for joining us on this edition of Spectrum.
Good evening, Anderson, and to our dear listeners.
Also in studio, Advocate Jude Byamukama is a constitutional lawyer. We know him for a number of cases that he has been involved in, including presidential petitions. Good evening, Jude. Thank you very much for joining us.
Good evening, listeners.
And joining us on the line is Brigadier General Felix Kulaije, UPDF and Defense spokesperson. Good evening, Brigadier General Kulaije, and thank you very much for joining us. Right, the technical team is trying to get to Brigadier General Kulaije so that he can join us on the line. But very quickly, let me begin with you, Jude Byamukama. This ongoing debate on whether civilians can be tried in the court-martial or not, what is its grounds, and why is it so important when you look at aspects of rule of law and constitutionalism?
Thank you. There are a number of issues that we have regarding civilians and their place in military justice. First of all, we have to understand, world over, military tribunals, or what in Uganda we call a court-martial, are for administering military discipline. Military discipline means people who are in the forces. Every profession generally has a regulator. As lawyers, we have law counsel. When as lawyers we commit professional malpractices, a malpractice might in some cases be a criminal offense, but also law counsel as our regulator of lawyers will also weigh in and can impose a penalty, can impose a fine, or can even stop someone from practicing law. Doctors and dentists also have the medical and dental practitioners council. It does the same. Engineers also have one. Surveyors have one. Architects have one. Even teachers, under the Teachers Bill, which Parliament is considering, will also have the equivalent of a Teachers Regulatory Council, more or less, to administer a discipline among teachers for professional misconduct. Now, world over, military tribunals exist within armies to perform the same role. There will be those cases which a soldier, a member of the armed forces, may engage in certain forms of misconduct which need to be addressed within a professional context. That is how military justice and how military tribunals operate. Now, in Uganda, we did something went horribly wrong when the UPDF Act was passed by Parliament in 2005. It created a scenario of what it called service offenses. Now, service offenses, to the ordinary ears, that sounds a very harmless phrase. If a soldier commits a service offense, that is easy to understand. But now they went ahead to define a service offense to include literally any criminal offense committed by a soldier. And that was the first problem. So when a soldier commits murder, they'll treat it as a service offense. Aggravated robbery, they'll still treat it as a service offense. And yet when you look at how military tribunals operate, a service offense should be something like desertion, something like cowardice, something like misuse of stores, when you misuse firearms or ammunition. Those are service offenses. But now in the UPDF Act, which was passed in 2005, it totally rewrote what a service offense means to include literally any offense committed by a soldier. Then they smuggled in civilians and said if a civilian aids and abets a service offense or commits a service offense together with a member of the forces, then a civilian can also be charged under the court martial. Then they went further and said if a civilian, they created that offense of if a civilian is found in possession of either firearms or materials which are ordinarily preserved of the army, a civilian can also be charged before the military tribunals, which in our context we call the court martial. Now that was a complete rewriting of who can be, of one of the purpose of military tribunals generally, and who can be charged. Why? A military tribunal by its very nature is not designed to be a court of law. When you look at our constitution, Article 28 of our constitution requires that a person should be, who is arrested and charged, should be tried before a tribunal that is impartial and fair. When you look at the composition of the court martial, and I'm not saying it should change, because that is how it is designed. A court martial is obviously chaired. The chair of the court martial is either a brigadier, is either a general, is either a lieutenant colonel, or whoever they put. Those people are under a commander-in-chief. They do not take a judicial oath. Judges and magistrates take an oath saying, I, Anderson, having been appointed a magistrate or judge, swear to administer justice without fear or favor, without ill will to anyone. I'm just paraphrasing. In other words, when you take a judicial oath, it requires that you must administer justice without fear or favor.
But there are times when
armed forces
there are times when we have seen judges who don't actually live to the judicial
oath. Living it is one thing,
so
but that's the oath. Now, in the armed forces, even if you look at the oath which members of the court martial take, they take an oath to be loyal to the commander-in-chief. That's a huge difference. And it exists because the commander-in-chief, in fact, can even direct them and say, please, discontinue the proceedings against Major Anderson. Stop, don't charge him. Yet in the civilian system, the commander-in-chief or the head of state can only come in after a person has been processed. The president can issue pardon. But even then, actually, pardon for people who are convicted. Under our constitution, it's regulated more strictly than other countries. The president can only act on a report of a committee of the prerogative of mercy to take a decision. Some other countries, the president can pardon a person when they are being charged or as soon as they are convicted. But our constitution put it very differently. And therefore, it's completely disappointing. It's frightening that we are going back to 2005 when this debate first really started. 19 years later, we are moving back to 19 years ago. It's very disappointing.
All right, but Jude, I want to put it to you that the circumstances you've put across are almost also similar even in the normal civilian courts. We have seen circumstances where the judges will not follow the laid down procedures to deliver justice. I'm sure you've known some instances, but you people in the legal profession have also been complaining that there are some judges who are actually taking orders from the Attorney General, from the President. Those instances have come across. Of course it can happen. A judge, but you see, a judge may choose to be influenced. That does happen, and nobody is going to. That's why we can complain. Okay. But nobody is going to complain that a brigadier general who presiding over the court martial has been influenced by the president. Of course, the president is his commander-in-chief, and he takes an oath to be loyal to his commander-in-chief. So they actually shouldn't even be misconduct or unethical. For a judge,
when a judge is unduly influenced by anyone, including the president, that is unethical and improper judicial conduct.
All right.
But for soldiers, that doesn't exist. For our brothers and sisters in the armed forces, that concept totally doesn't exist. The commander-in-chief is your boss.
All right. Let's hear from Council Wanda. Council Wanda, this debate has been going on, but wherever it comes up, like you've said, it has been on for the last 19 years. The army will tell you that, look, the reason these people are being charged in the military court martial is because they were found in possession of things that belong to the army. So they need to be taken there where such things are actually handled.
I think you understand. Of course, we disagree with that position. Yes, 19 years back, we should have had this discussion. Our legislators should have been very clear, and they should have ideally distinguished most of these things. But nonetheless, the Constitutional Court has on 3 occasions pronounced itself on whether civilians should be charged in the court martial. And the Constitutional Court has said no. And the reasons are very basic. Because there is no independence, as my brother Jude has said, in the court martial. There is no room or even a semblance that court will be fair. Why do we say it cannot be fair? When you look at the person who is the accuser, that will be the military. When you look at the person who is the prosecutor, it will be the military. When you look at what we would call the bench, that's the chairman and the members of the tribunal, it's the military. Now, in some instances, they even go ahead to give you their state defense, who is also part of the military. So there is no any semblance of fairness. And that's what the Constitutional Court has said in the Kavaziguruka case. I think shortly after the act was promulgated, Uganda Law Society went to court in 2006 and challenged the same. And the Constitutional Court agreed with them. The Attorney General even appealed to the Supreme Court. And the Supreme Court said no, civilians should not be tried in the military court because of its lack of independence, and there is no belief that it can be fair. Now, they've gone ahead, still charge people. We've seen the Kawazuka case. He also challenged them in the Constitutional Court. He won in the Constitutional Court. The AG went to the Supreme Court and got an interim order for stay. And that's how they can continue charging in the General Court Martial. But it's absolutely wrong to charge civilians in that court.
And by the way, maybe to say something, Anderson, obviously we are missing the voice of Brigadier Kulaija. I was interested in it. I'm very interested in hearing from him, his perspective. But just to give a little more finer detail, because I've been heavily involved in this process. Just yesterday I was in the Constitutional Court trying to ask them to nullify a criminal trial which was concluded, where a civilian was charged with murder and convicted and is serving a jail term. But there have been 2 roadblocks, and that's also the other problem, which I think Ugandans must pay close attention to, because I think it's a I think it's a grave scandal that this should be happening. The Supreme Court, actually in Uganda Law Society versus Attorney General, in 2009, clarified, gave a position on if you are to charge a civilian before the court martial, what are the benchmarks? Okay? Those benchmarks included that if you are going to charge someone, first of all, they must have aided and abetted the commission of a service offense, which did not exist in the circumstances of 2005. When you look at the current charge sheet with which Dr. SJ is charged, it totally falls within the ambit of the Supreme Court decision of 2009, which specifically pointed out that you can't charge a person just because that you have found them in possession of firearms. And by the way, the current charge sheet says Dr. SJ and his co-accused were found in possession of pistols at Riverside apartment in Nairobi. For heaven's sake, the UPDF Act does not apply outside Ugandan territory. No one should be misled to believe that the UPDF Act can apply. If you plot to overthrow the government of Uganda and you do so outside Uganda, that is different. Okay? If you plot to commit terrorism in Uganda, but you do so from outside Uganda, you do so from Kenya, you do so from Somalia, you do so from DRC, you can be charged in Ugandan courts. But just possessing a firearm and you are in a foreign country does not contravene Ugandan law. Otherwise, if that were the case, a large number of Ugandans who live in countries where owning firearms is legal would then be, they are all committing offenses in Uganda, as you know, in the United States.
Well, they will tell
people
you
are free to own firearms, including even AK-47.
They will tell you that in the East African community, there is cooperation to deal with cross-border crimes, and probably that could be the ground.
That wouldn't be the issue. And then second,
why wouldn't it be the issue?
Because for possessing a firearm within Kenyan territory, you have to first ask yourself: does Kenyan law permit possession of that fire? Does Kenyan law permit possession of that firearm, or it doesn't? That would be the test. The test cannot be that you are a Ugandan and you had a firearm while you were outside Uganda. You were found with a firearm outside Uganda. Of course, Ugandan laws do not apply outside Ugandan territory. That's critical. The exceptions are those transnational crimes. Possession of a firearm is not a transnational crime. Terrorism can be a transnational crime.
Proliferation of small arms.
Treason can be. No, that is just a term. Otherwise, you see it. We have this, for example, in you have Ugandans who cross over to the Turkana region, and maybe some of them will have firearms when they're in the Turkana region, then they come back to Uganda. They know they shouldn't have firearms in Uganda. You can't charge them. But maybe before I lose the key point, I wanted to explain. When Michael Kabazuguruka was charged in 2016, just after the 2016 elections, remember it's a common pattern. Politicians are usually those who are charged, and usually around the election period. 2005, Dr. Besigye was charged before the 2006 presidential elections. 2016, Michael Kabazuguruka was charged. Actually, it was less than a month after he was declared MP elect for Nakawa constituency. When he was charged, he went to the Constitutional Court. And by majority decision of the Constitutional Court, they actually ruled that civilians cannot be charged before the court-martial. That judgment, the Attorney General got a stay of that judgment. But you know, when the court stays a judgment, they are simply saying, maintain the status quo
of the judgment.
You were driving a car going to Mukono, but
stay on the lane.
Stay on the lane. Wait, don't move, don't go backwards, don't go forwards. Now, when they continue charging people in the court-martial, they are technically defying the decision, even if they have a stay. And that for me is
doesn't the state say that let the status quo prevail, continue doing what you've been doing? No.
Status quo doesn't. Status quo means a stay of execution. A stay of execution is simply saying we are not going to implement this court decision now. Let's wait.
All right.
So you are supposed to freeze everything as you pursue your appeal, which they are not doing. And I understand the Attorney General may have a different view. I hope you can eventually host his team and they explain to the country why they think otherwise. But that's the situation.
All right, Advocate Wanda. So let's look at a situation where people are found with ammunition and guns, etc., which belong to the armed forces. How would we prosecute them in case we fear they are a threat to society?
Kenneth, I think one thing we need to first understand is if you found someone in possession of firearms, is the possession lawful or not lawful? And then two, if you want them in possession of firearms, because I'll make reference to this charge sheet. Found in possession of a pistol, K-, which is a preserve of the defense forces. Which defense forces? Are we talking of the UPDF? Are we talking of the KDF? You can see even the charge sheet even itself, it's narrow. It can't, the statement of particulars cannot ideally indicate exactly what the offense is. And yes, indeed, if you found someone with guns, you found them with a pistol or any other machinery that is a preserve of the UPDF, the courts have been very clear that let them be charged. For as long as they are civilians, let them be charged in the ordinary courts. Because if you think you have a case against them, you can still prove their guilt in the normal court. And the purpose of this is because we believe, and the courts also believe, that there is independence of the judiciary within the normal court system, and there is fairness is expected in such courts. Still, you see, they talk about service offences, and then I took time today to read through the UPDF Act as amended, and you look at, yes, there's service offence, but then there's service, and service is very clear. It's someone who is serving in the armed forces. So I cannot commit a service offence if I'm not in service, and therefore I shouldn't be charged of any service offence within the UPDF General Court Martial. So that's the best argument about that. So even if I'm found with guns, let me go through the normal trial in the ordinary criminal courts in Uganda. It may either be a magistrate's court, I can be taken to the High Court, they can change the jurisdiction of the courts, and then they specify that if you're found in possession of firearms, which are preserved with the Uganda People's Defense Forces, let you be charged, and the jurisdiction of that case should be the High Court, like how they have other jurisdiction of terrorism, aggravated robbery, among others.
All right, staying with you very quickly, Council Wanda. Jude talked about the setup of the court. We know there is a panel with the chairperson. In this case, it is Brigadier Freeman Mugabe at the moment. But what I also saw there is a judge advocate, and then it's interesting when Dr. Besigye had just been taken into the dock, there was a proposal to actually accord him lawyers from the state, which means they're almost operating like the normal judiciary. What's your take about that setup?
The setup is not, and is not even akin to the normal judiciary. As we've all agreed that they have a judge advocate. Now, the judge advocate actually directs the tribunal.
Or advises?
It's a directive. Because at least they normally go by what the judge advocate has directed or advised. So there's a chairperson plus the tribunal of about, I think they're about 8.
So the judge advocate is a trained lawyer? So the judge
advocate, we don't know his qualifications. Yes. But at least we presume he's a lawyer.
And the chairman?
The chairman has no qualifications. For as long as he's in the forces and the president deems fit for such person to be the chairman of the tribunal, he will be. Because we've had like the late General Eli was a chair. He's never been a lawyer. So
we had the late is that Eli Tumwine.
Even
okay.
I think even Levy. I don't know if Levy was.
Karuhanga.
I don't know if Levy Karuhanga was a lawyer. Yeah, but so they have no qualifications in law. And that's why probably they have a judge advocate. You may find his qualification is a diploma in law.
No, actually, a judge, just maybe to interject, a judge advocate is actually a trained lawyer, and the purpose of the judge advocate is to give some guidance, more or less, on legal matters. But obviously, that has its own pitfalls,
right.
like we have seen over the years, because the court martial, the unit disciplinary committees, the court martial appeals court, when you look at the quality of justice they claim to administer, it's simply a shame. Not just for civilians, by the way, and I don't want us to think that the way the court martial is set up, that it is fine for the soldiers as well. It simply isn't. When they start trying them for offenses under the penal code, it's a big problem.
All right, Spectrum on Radio 1 FM 90. Let's go for a break now. When we return, we'll try to see if we can reach Brigadier Felix Kulaje, but also we will be digging deeper into some of the issues that are happening before the General Court Martial. For instance, if the lawyers are saying it's not proper for civilians actually to be charged before the military court martial, why then do they render their services there when called upon? Why are they submitting themselves to such a court that they believe should not be hearing such cases? Now stay tuned to Radio 1 FM 90, but keep your comments coming via the WhatsApp line 0703 090 090. All right, thank you so much for staying with us on Spectrum Live on Radio 1 FM 90. Today we are looking at the continued discussion or debate about the trial of civilians before military court martials. Today, Dr. Kiza Besigye and his colleague Obeid Lutale were actually arraigned before the court-martial in Makinde, having been arrested, people are saying arrested, kidnapped from Nairobi, where Dr. Besigye apparently had gone to take part in a launch of a book written by Kenyan politician Martha Karua. He was supposed to appear at that function on Sunday, but when he did not show up, they started looking around for him. Then the news started spreading that he was missing. Now he has already been taken to Luzira, where he is on remand until the 2nd of December, having been charged before the military court-martial. My guest this evening, Mr. Jude Byamukama, constitutional lawyer, and Mr. Ronald Michael Samuel Wanda, who is also an advocate, and I saw him in Makinde actually attending those proceedings. We were expecting Brigadier General Felix Kuraije to join us on the line, but he has just communicated to us that he has a sudden engagement and he cannot be able to join us. Nevertheless, we'll continue with this discussion. And I'll ask you, Wanda, you went to that court and there were a number of lawyers there. If you lawyers actually believe that the military court-martial is a no-go area for justice, why do you appear before it?
We have a constitutional mandate to represent people. And the reason why we go to that court is to inform them of whatever they are doing is an illegality, and therefore they should stop. Because if we leave the litigants to do it by themselves, then they will not do it, or they don't know that they are supposed to do it. An example I'll give today is that we told the General Court-Martial that what you don't have the jurisdiction to try Kizza Besigye and Obeid Lutale, because they are not serving military officers, and therefore you don't have jurisdiction into this case.
But they looked at the law, and the chairman of the court-martial actually ruled and said, having looked at what the law says, they found that the two were actually before the court-martial in the right way. Actually, for the first time, I saw actually the military number of Dr. Kizza Besigye being attached to the charge sheet.
Yes, you see, when someone makes a ruling, it doesn't make it right. It may be wrong, it may be right. And that's why in the normal court system, we have all these procedures available for us, that when something is not right, you can appeal or apply for revision or review to another higher court. Now, us continue going to these military courts, even when we believe they are unconstitutional, is because if no one is going to tell it to them that, look, what you're doing is unconstitutional, then they will continue thinking that what they're doing is right. Now, even Dr. Kizza Besigye raised the same objection today, because they asked him if he has an objection to the tribunal. I said, yes, I have an objection, because I'm not a military man, I'm retired, and if I've committed any offense, take me to the civil courts, and I'll stand trial, and then they can prove my guilt. So we can't stop going there because we don't believe that the courts have jurisdiction. Otherwise, we would have conceded, and then they can go ahead with all their thinking and continue trying people.
All right. Let's look at one other key talking point in this particular matter is the fact that these people are being arrested from another country and brought into Uganda. We began with what is called the is it the 36?
36 Kisumu.
The Kisumu 36.
Yes.
Who were brought in here and charged. Now we have Dr. Kizza Besigye and Obeid Lutale. And I'll come to you, Counsel Byamukama. What's your take on that? Is there any illegality? Because what I'm reading even right now from social media and the comments that are coming in from numerous politicians, they are demanding for action against the Kenyan government. And I've also seen statements from key political figures in Kenya who are also saying that the Kenyan government must demand the immediate release of Dr. Besigye and his colleague.
Yeah. First of all, there is a procedure when somebody is not on Ugandan territory and is wanted by Ugandan officer or by the Ugandan government to answer for any crime, they have to go through an extradition process. Typically, like for Uganda and Kenya, there is an extradition arrangement whereby when a person is in another country and is charged with an offense, we have international norms which govern how people are moved. These international norms arise out of the fact that sometimes people have left their home countries because they are fleeing. Either they are seeking asylum, or they are simply running away, or they have simply gone for a better future, and they have not committed any offense at home, and yet their home countries might be pursuing them purely for political persecution. So, because of that, world over, extradition treaties exist between countries, and one common theme in extradition treaties is that a country should never return a person to their home country against their consent unless there is proof that they are suspected of having committed a crime, and that crime should not be of a political nature. In other words, general extradition law does not permit, for example, repatriating someone back to their home country to answer charges of treason. Treason is an offense of a political nature. So, between Kenya and Uganda, between Uganda and other East African countries, I don't recall, Uganda didn't have one. It was a bit of debate about it some few years ago.
But we know there's cooperation on the front of security.
Cooperation.
The police
cooperation has no force of law.
Maybe they have signed something.
In fact, that debate first arose when General Kale Kayihura was being accused of forcibly repatriating Rwandese.
Rwandan nationals.
Yes, in absence of an extradition process. And I remember there was a position from the Uganda police claiming they had an MOU with the Uganda police.
Can you explain what entails in an extradition process?
So
and if you can use the example of the Dr. Besiges, and where you think that process was not
basically followed. Means Dr. Besige should have been arrested, taken before a court in Kenya. Then that court in Kenya would determine whether Ugandan authorities should be permitted to pick him and bring him here. That's how it works. If you recall, ADF commander Jamiru Mukuru went through that process in Tanzania. The Tanzanian authorities didn't just hand him over. Although I recall there was a complaint that they denied him the right to appeal. But he went through a court process, and it was determined that he had committed offenses for which he needed to be released to Ugandan authorities to come and answer. And then he was processed and brought to Uganda. Everyone who is on foreign soil is entitled to go through such a process. And maybe, for example, the Ugandan authorities in Kenya would have been asked, which offenses has Dr. Besige committed? Then you see, they wouldn't have passed that test. Because the first offense they are complaining about on the charge sheet is that he had a firearm in Kenya. Then the Kenyan authorities will say, if Dr. Besige has a firearm in Nairobi, how is that a Ugandan business? If at all he had it, I'm not assuming, by the way, that he had it. Okay, we have to have that in mind as well. How would that be? The Kenyan authorities, obviously, and the Kenyan courts would tell them, no, this is our business. If Dr. Besige commits an offense in Kenya, on Kenyan soil, he will be tried by Kenyan courts. If the Kenyan authorities don't see any offense he has committed, a Ugandan authority cannot start complaining that Dr. Besige has done something in Kenya.
All right.
That's
one issue.
And that's the purpose of, that's what goes through in an extradition hearing, where the foreign court makes a determination as to whether this person should indeed be handed over to go and be tried in their home country for an alleged offense. And that's the purpose of that process. It has not been gone through here, and clearly we can see on the face of this charge sheet that we have seen from the court martial today, definitely no Kenyan magistrate or judge would have granted that extradition. No wonder they had to use underhand methods to somehow bring him to Uganda.
Wanda,
yes.
What's your take on that?
My take on that is, of course, it's illegal. As my colleague has said, is that there is a process. And on the face of it, the process was never followed. He's arrested on the 16th, and it's on the same day he gets disappeared, and on somehow on Wednesday is produced in a court in Uganda. Now, when you look at the Kizza Besigye, the Kisumu 36 people, none of them has exited Kenya legally. When the Kisumu 36 were arrested, they were put onto buses and were driven back to Kampala without their passports. And to date, they don't have their passports, they don't have their national IDs. Dr. Kizza Besigye does not have his passport today. When he was arrested, by security forces, whom he believes some are Ugandan security forces. He was just brought back to Uganda through the Malaba border post. So that in it is in itself illegal, because he entered Kenya in a legal manner. The immigration of Uganda allowed him to exit. Immigration in Kenya allowed him entry. Then the same process should happen. If someone is leaving, let Kenya allow him exit, and then Uganda allow him entry again back in his country. So all this has not happened, and because the other maybe would have been a deportation, and the deportation would happen if you've committed a crime in Kenya or you've entered there illegally, and the same has not happened. And the state seems to be casual about it, because they think now they can pick people and then bring them back to Uganda without anyone calling them to order.
All right. We have comments that are coming in from the listeners, and I'll begin with this comment from Kauma Dige, who is listening in from Mitiana. He says, Anderson, who should be blamed for this mess? The court-martial, the legislators who made the law, the executive that initiated the law, or the judicial officers who have not quashed the bad law? I'll begin with you, Biamkama.
Just clarify, the courts did their work. What is happening is sheer contempt and disregard for judicial decisions. So the courts cannot be faulted. Neither is what is happening within the ambit of the UPDF Act, because it is not. This is just a process that is completely lawless. That's what people need to understand. They are going to use the court-martial to try to give it some sort of legality, but it's not a lawful process at all. We have a decision of Uganda Law Society versus Attorney General. We have a decision of Michael Kabaziguruka versus Attorney General. We have a decision of Captain Amoni Byarugawa and 400 others versus Attorney General. They have all clarified. Just because the implementation of those decisions has been stayed does not give a leeway to the court-martial to continue doing what the Constitutional Court has said is unlawful. At any rate, what should have happened, in fact, is they should have stopped charging anyone and trying anyone until those appeals are concluded. We hope the Supreme Court can get this out of the way quickly, since there is clear contempt for the decisions of the Constitutional Court. But again, it's also important to note that even in 2009, although the Supreme Court had ruled that the Besigye and group had been unlawfully charged, the army continued to hold them continued to try them for over 3 years after that. It's important to note that.
All right.
Because this is not about respect for rule of law. This is not about equality before the law. This is not about the court-martial saying it's going to administer justice. This is exercise of brute force, because the army has the capacity to do so. Right. It has nothing to do with the law.
All right. Wanda, can Parliament remedy this? Do you think the ball should be kicked to Parliament, or we should stick with the Supreme Court and make sure that they actually have a final say on this matter?
You see, when we talk about Parliament, at times I get disturbed on how we can ask them to remedy some of the problems we have as a country, because they seem to be interested in things that do not matter much and leave those that matter. Mere fact that they
left what they ought to have done,
yes,
and they did what they ought not to have done.
Because
is that what you're saying?
Yes, mere fact that the Constitutional Court has pronounced itself. You see, the Constitutional Court is the court mandated in this country with interpreting the Constitution, and once they have given a judgment, then that judgment should be looked at with wide eyes.
We actually told that decisions of the Constitutional Court can amend the law. Is that so?
Technically, they should
knocks the law of the books of statute.
Yes, technically they do that, but again, it's now the legislature is supposed to come and look at what laws have the Constitutional Court declared unconstitutional, and then remove them, and then give us other versions. Now, the Uganda Law Reform Commission, that's part of its work. Look at what has happened, and then try to rectify the wrongs that the Constitutional Court has said these are wrongs. Right. Now, our Parliament does not really think that they can look at these things so quickly and have a determination on them. But again, also, it's control. Does it have a control? Can it determine whether the UPDF should try civilians or not, because they seem to be in captive themselves.
All right.
I mean, we've also argued that we shouldn't have MPs who are from the UPDF in Parliament, but they have never decided on that.
All right. We have another comment coming from Iga Samuel Mary, listening again from Namlondo Zone in Boyogere. He says, let's say that Kano Besigye and a colleague were found with the firearms. Is it right for the Ugandan army to operate in Kenya? Another thing, for how long will Uganda's government go ahead to violate other countries' laws? Ultimately, the government of Kenya has to explain thoroughly about Kano Kizza Besigye's situation that he calls an abduction. We have a comment coming in from Okello Patrick Bonyo from Busega. Our system here is just a mess. Anything is possible provided it suits someone. Those who acted in this movie of arresting Besigye from Nairobi made a blunder, and it favors KB politically. Kenyan government should have been the one accusing Besigye of holding a firearm in their country illegally. That's a comment from Okello Patrick Bonyo, listening in from Busega. George writes in, good evening, Kenneth. George from Bunga, does this punch holes in Dr. Ruto's leadership? Dr. Orengo on social media indicated clearly the Kenyan security agencies were involved in this ugly act. That's a comment there from George. Another one comes in. Good evening, Kenneth. Thanks for the legal brains in the studio, especially lawyer counsel Judy Amukama. This again comes to the will of the government to fight crime and also prosecute its opposition. It should come out clearly on matters of acquisition of firearms for civilians. When is a civilian supposed to possess a firearm? When you arrested, you are supposed to be charged in court-martial or civilian court. Otherwise, the government risks being misunderstood as political persecution. It's a long comment, but I could only do that at this particular point. Then we have another one from Esau Turiatunga, who is listening in from Nigeria. He says, if Besigye is to be charged, he should be charged in Kenya for breaking Kenyan laws, holding illegal guns in Kenyan territory. You can't steal a hen in Uganda and they charge you from South Sudan. Everything here is bogus. That's a comment from Esau there. And then we have another one coming in from Chris Kasaija. He says, political persecution of Dr. Kizza Besigye. My heart and empathy goes out to the good doctor and freedom fighter, plus the family. God will avenge this. It's just a matter of time. That's a comment from Chris Kasaija there. We have another comment from David. He writes in and says, if an armed robber raids Judas and probably injures him or his member of the family, but thereafter the robber is apprehended and tried before a court martial and executed, would you be happy or not about that action against the robber? That's a question that comes in from David. Then we have another name, Isaac Mukasa. I think we deserve an explanation from the Kenyan High Commission in Uganda. What Kenya is fueling might not turn out to be well. Should this continue under the Ruto administration? No wonder he is facing difficulties. We need an explanation, and you should put the Kenyan High Commission online if possible. Unfortunately, we are unable to do that at this particular moment. Lastly, we have a comment from Dennis, who writes in and says, is Dennis Ojwang Wesonga. He's listening in from Namagunga. He says, now, if Besigye has no passport, how did he reach Geneva, where the intelligence says he went for a meeting? Then he says, now, if Besigye, he says, it's almost the same comment that he has sent several times. Well, gentlemen, that's a feedback that we have from the listeners. So let's respond to some of the issues. And if there are any issues you think you need to clarify,
yes,
and then
course.
We'll wrap it up.
Just listener, I think that's David, is asking. No, I wouldn't be happy if an armed robber of whom I'm a victim is tried and executed in the court martial. We should wish fairness and fair trials, even on the worst of our enemies. It's very important. Because if we start, you see, vindication is not justice. There is that human tendency of thinking, if someone has stolen my phone and is killed by a mob, that is fine, even though the phone maybe is worth 300,000 shillings. That is raw human instinct. But fairness, you see, justice is blind. When you look at the courts of law, people who have committed murder are sentenced to 30 years imprisonment, 35 years. And some of them get bail during their trials, they move on with their lives. So we need to be able to appreciate that even criminals deserve a fair trial. Nobody deserves a kangaroo process. Why do we discourage, and why should there be no kangaroo process for anyone? Because the possibility that innocent people will be caught up and executed in kangaroo processes is extremely high. And it is not like we have not experienced that before in this country. It's not like we haven't seen it even in the court martial. Even in the ordinary courts, by the way, it can happen. Innocent people also get convicted in our ordinary courts of law. But that risk is is over 100 times higher when you cross over to the military tribunals, to the court martial, to the unity disciplinary committee, to the court martial appeals court. Because now there, the standard is even completely different. The possibility that a person who is at loggerheads with the commander-in-chief of these very senior officers can get justice in the court martial is simply non-existent.
All right, Wanda, would you like to respond to some of the comments that came across?
Yes, and particularly, I'd like to talk about the Kenyan High Commission in Uganda. When we had the Kisumu 36, a petition was delivered to them to give us some answers. These questions were asked on how did they leave Kenya back to Uganda. We just thought for some answers. To date, we haven't received any. So I do not think it even has the tooth to even talk to us and tell us this is what actually has happened. I saw there was a comment from someone.
That is David.
That's David still. David, yes. You see,
just for you to go to the court martial and tell them that it is legal to try civilians does not and will never stop it from doing so. So in reality, your verbal attacks on court martial is an exercise in futility. That's what it says.
Yes, David, what we are doing today is not may not necessarily be only to our benefit. What we are doing today will be for the benefit of everyone in this country. David, tomorrow, if anyone is charged under that law, taken to the general court martial, which we believe should not be done, it's wrong. And that's why we are saying it out today. We shall not keep quiet over something that we believe is illegal, because we believe that the general court martial or the executive will not implement what we are urging it to implement. So we shall continue going there.
All right, we have a comment coming in from Charles, who is listening in from Nairobi. He said, don't forget about the presence of William Ruto was by President Museveni. At one point, Ruto was barred from crossing to Uganda, so Kenya is Uganda's next home now under Ruto. Gentlemen, could this be a political issue? Somebody doing the other political favor? Or what could be going on?
Well, obviously, the Kenyan situation has not been any better. There are so many cries from Kenyan civil society, from Kenyan politicians, about the rising cases of disappearances of people even within Kenya. And so it's this appears to be, the Ruto regime appears to be taking Kenya back to the Moi years. So it's also, of course, of concern, given that we are all members of the East African community.
Yeah. Actually, see, today, because we are Ugandans, so we are looking at the Kisumu, we are looking at the BSCJ. But I think about last month, Turkish nationals were also handed back by the same regime in Kenya. So there seems to be a problem with Kenya as a country, to me.
Finally, I'll put this question to you. How do we get the Kenyan government to actually explain this? It's one of the things that has been proposed by the listeners. How do we get them to explain what has happened? Is it through legal action? Is it through diplomatic means or petitions?
I think it's going to be a multiplicity of tools. You need some, obviously there's need for legal action. There's need for diplomatic engagement. Because I think, like I've said, for me, this is, while the legal process must also play out and people must definitely challenge these actions before the courts of law, I think what we have is a battle to try to change hearts and minds. It's not really because this is not about the law. It's not a legal problem that we have. It is a political problem.
All right.
It's not a legal problem.
All right. I'm afraid time is not our best ally. We have to bring this discussion to an end. Let me thank you, dear gentlemen, for actually making time to be here in studio, but also the listeners who tuned in and contributed to this discussion. Up next, we have the news in English with Miss Josephine Dagano. Thereafter, we'll have the Soul Train with BB Junior. But for me, your host in studio, it's a good night.